May I have your lordship's kind leave to mention a matter?
Infusion.
Your lordship, no, your lordship had passed an order dated 5th March, your lordship, wherein your lordship had directed to return of claim, citing a notification dated 15th November 2018. Second page of the order, your lordship.
Yes.
Wherein, your lordship, the bench was constituted only on March 20, 2020. I have annexed the gazette notification in the last page, your lordship. That is why, your lordship, the suit was filed in this division. And it will be not, your lordship, return of plaint. I bow down to your lordship. It shall be transfer of plaint under section 15 of Commercial Codes Act. Your lordship may kindly fix this matter as to be mentioned tomorrow, or your lordship will direct, we will file an application. As your lordship.
You have to come with the application then. Recalling application. When I pass this order, I definitely have perused that. There was earlier order. I have seen that.
So it is only possible, my lord, if the suit was filed and if the suit was already pre-existing.
Yes, pre-existing suits are transferred.
But this is not a pre-existing suit.
Yes.
The defendant wants to file an application.
You have to file formal application.
Grateful, ma'am.
Just a minute, wait please. There are orders. Right now it's not available yet. It was there. I have seen that.
But may I
So
have
take it back.
your lordship's leave to mention the matter? My lord, this order was passed by your lordship on 20th February 2025. I am praying for this matter to be listed as to be mentioned tomorrow. But the urgency is, my lord, I did not know about the nature of the order which was passed, because by this order, lordship had directed the official liquidator to hand over symbolic possession of a particular property. The property was not mentioned in your lordship's order. Yesterday, we receive an intimation from the official liquidator saying that the symbolic possession will be handed over tomorrow. My lord, tomorrow. My lord, that is why, my lord, we are.
One thing. কোথায় গেল ওরা? Come tomorrow, mention tomorrow.
That the difficulty is, well, the official liquidator.
I understand your difficulty, but I have no the hands. I must have hands
My lord, absolutely.
for noting this submission.
Yes.
Come tomorrow. Company matter is fixed tomorrow.
My lord, may I only indicate this, that, my lord,
If you come tomorrow, then I can fix on Thursday.
But in the meantime, I shall be praying for a limited stay of this order. But I shall indicate tomorrow.
Without anything else,
But
without
I
even the
understand.
bench.
Yes, but I understand. But I'll come back tomorrow.
Come tomorrow.
Grateful.
এটা নিয়ে নাও, অ্যাপ্লিট সাইডের লিস্ট নিয়ে আমি কি করব?
Origin side, commercial division, item number 1.
Item number 1, your lordship, I am for the plaintiff.
So I have your
Defendant suit.
আরে লিস্টটা দাও।
In the undefended suit.
Commercial matter. Mr. Sengupta,
Yes, your lordship.
I need clarifications.
Yes, your lordship.
Money was lent in the year 2011.
Lordship.
So ideally limitation period, there is nothing is mentioned that money will be returnable on such and such date. Your plaintiff is silent.
Yes, your lordship.
So obviously 3 years is the limitation period.
Yes, your lordship.
That limitation period may be extended
Lordship.
either by acknowledgement in writing
Lordship.
or by part payment.
Or by part payment.
There is no acknowledgement in writing.
I'm showing your lordship. I'm showing your lordship that it's a part payment.
Part payment is not proof because
Yes, your
there is no payment made by the defendant. There is no such proof. It is receipt issued by you. And that point was taken in cross-examination.
No, in the receipt taken by me, but that particular receipt has been
Is
given
there
to them.
anything else to show that they have payment? They have made the payment.
Your lordship, that is in cash. That is mentioned in your lordship, the
That
ledger.
doesn't prove it. First thing. Second thing,
Yes, your lordship.
still, when a date is time-barred,
Lordship.
a time-barred date can be revived.
Lordship.
If there is agreement in writing under section 25C of the Contract Act,
Lordship.
where 25C is an exception, that contract without consideration is void.
Lordship.
If there is any agreement in writing,
Lordship.
now Supreme Court has decided that whenever you will issue a check, a kind of contract or kind of agreement is presumed.
Lordship.
So let me presume first that check was given, it's a time-barred date. Check was given in the year 2017.
17.
It was dishonored. and within 1 year, check this case was filed.
Lodge.
Now they have filed one document, exhibit number 1,
Lodge.
that has no evidentiary value except contradicting your statement.
Lodge.
That contradicts that check was issued in 2017. Rather, it was issued in 2014.
Lodge.
So 2014 it was issued
Lodge.
within limitation period.
Lodge.
So 25C doesn't apply.
Lodge.
So your suit is obviously time barred.
Lordship. May I now proceed, Your Lordship? On
Yes.
that basis, Your Lordship has already expressed. Today, one thing, Your Lordship, always keep in mind, Your Lordship, there is no written statement. But still, Your Lordship, the courts have powers under Section 3 of the Limitation Act to see whether my claims are barred by law of limitation or not. There is no agreement, Your Lordship, that is very obvious.
Even
Your
no
Lordship.
defense is taken. Section 3 says even no defense is taken.
Even if no defense is taken, it's the, Your Lordship, the court can suo moto, Your Lordship,
Yes.
seize before passing a decree, Your Lordship, whether my claims are barred by law of limitation or not. On that basis, Your Lordship, I am proceeding, Your Lordship, to show
Yes.
whether, Your Lordship, I can succeed, Your Lordship, that whether this particular claims are barred by law of limitation or not. Should kindly take my plaint once. Lordship, Exhibit B at page 16.
Exhibit.
Rather Annexure B at page 16 is, Your Lordship, the bank statement, where from, Your Lordship, it shows, Your Lordship, the money has been given to
I was
them.
only looking to the evidence. This is suit. Where is the
problem.
evidence?
Lordship, kindly take, Your Lordship, the judge's brief of documents.
Is it exhibited? This statement?
Yes, yes. Bank statement, sir. What the exhibit?
Which page you are referring to?
Lordship, I am referring, Your Lordship, page 4.
Page?
Page 4. Exhibit number 2.
Yes.
Page 4, Your Lordship, the amount, Your Lordship, has been shown. 50 lakhs have been paid to, Your Lordship, the defendant.
None is disputing that.
No problem, Your Lordship. Kindly come to your page 7. There is an admission by them, acknowledgement, 30th of March 2011. This is SNJ Fashions Private Limited on demand. We measures SNJ Fashions promise to pay Starlight Vyapar or order a sum of rupees 50 lakh received by RTGS dated such and such as loan for our business purpose.
There is no doubt.
No doubt. Now, Your Lordship, kindly see
It's
page 8.
undisputed fact.
No problem. Kindly come to page 8. Lordship, kindly sees, only appreciates one thing. There is no dispute regarding this particular document.
Cross-examination, these questions were put in cross-examination.
I'll show you, Lordship. These questions may put in the cross-examination, but there is no defense. He cannot dispute this document. This document has been exhibited without any objection.
Obviously, he cannot dispute because these documents were not issued by them.
No, yes, but Your Lordship, the contents. Lordship, kindly sees what are the contents. These are the money receipts issued to them by the plaintiff. And there is no denial to that. There has to be a defense. If the written statement is there, Your Lordship, I have to prove it. Page 8, there are 8 to 10, Your Lordship, there is a money receipt. Lordship, kindly sees and dates 11th of July 2014, 9th of September 2015, at 10, Your Lordship, is 20th September 2016.
That I've seen.
Now, Your Lordship, kindly come to page 11.
This check is there.
Check is there. 23rd of March 2017. He cannot dispute because there is no written statement. It has been signed by them. The particular witness has adduced evidence, and Your Lordship, that particular check, Your Lordship, has not been disputed. Page 11.
Only thing is that your point is this check was issued in 2017.
2017.
Exhibit 1 shows this was issued in 2014.
Lordship, I'll clarify that particular point. And now the thing is, Your Lordship, whether that particular
This
document,
particular check number, Exhibit 1 shows
Lordship,
it was issued in 2014 and they requested you not to deposit it.
that is only for the purpose of security. I'll show Your Lordship whether that particular Exhibit 1 also can be shown. Whether there's a scope, Your Lordship, at the time
Not
of
to contradict. That was that document was admitted in evidence on condition it will be used only to contradict.
Only to contradict. That's why, Your Lordship, I'm showing a judgment of the Supreme Court. That's why, Your Lordship, I clearly made an objection at the time.
So
Your
your
Lordship,
point is, I understand your
it's
point.
an admission. 23rd of March 2017, when the check has been issued, and if you have not filed a written statement disputing this particular fact, this is an admission on their part, Your Lordship, regarding the acknowledgement of debt. The issuance of the check itself is sufficient. He is not saying that Sharad Navalgaria, who is the person who has signed this particular document, Your Lordship, has not issued this check.
All right, I got your point.
And Lordship, and thereafter, Lordship, page 11, thereafter page 12, Your Lordship, is the written memo.
To me, the exhibits.
Yes, your, these are exhibited documents.
These are all exhibited.
Yes, yes, these are exhibited documents. And your lordship, when the exhibition documents were exhibit, your lordship, no objection has been made. That is also very important. Then if this is a forged document, fabricated document, you should have come and immediately your lordship made an objection. At the time, your lordship, even if your lordship is this particular suit, your lordship is an undefended suit, they may have come and objected with regarding this particular document when the document is marked as exhibit. Nothing has been done. Thereafter, page 12, your lordship, is the written memo. And even if your lordship, I disregard your lordship, the ledgers, thereafter, your lordship, the criminal proceeding has been initiated, page 22. These are your lordship, the complaint filed for cheating. Page 23, your lordship, 420, 406, 34 and 120B of the Indian Penal Code. Criminal proceeding has been initiated. Copy the only your lordship, one judgment your lordship I would like to show regarding their right. What is your lordship, what right they have at the time, your lordship, when there is no written statement, only to cross-examine on the basis of the plaint and document produced by me, nothing else.
Absolutely.
Now today, that particular document which he is producing, your lordship, cannot be taken into consideration. Apart from that, if your lordship kindly sees,
Why cannot be taken into consideration? Except when the document was admitted only on condition, it can be used to contradict and nothing else.
contradict my statements in the plaint and nothing else.
Absolutely.
Now your lordship kindly sees, once there are one paragraph from the Supreme Court judgment, if your lordship kindly consider this, and thereafter your lordship hear them, and what is their scope, your lordship, today before the
Yes.
honorable lordship, internal page 4, if your lordship kindly sees,
Paragraph.
your lordship 5, just bottom portion, last 3 lines, at this stage. Internal page 4, last 3 lines, your lordship, starts with at this bottom, your lordship, is page number 4 is written in bottom. At this stage, we must clarify the legal position. Even if a defendant does not file a written statement and the suit is ordered to proceed ex parte against
Cross-examine.
him,
Can always
the
cross-examine.
limited defense is available to the defendant is not foreclosed. A defendant can always cross-examine the witness examined by the plaintiff to prove the falsity of the plaintiff's case. A defendant can always urge, based on the plaint and the evidence of the plaintiff, that the suit was barred by a statute such as law of limitation. So he has to show from the plaint itself, pleadings and the documents.
And evidence.
Lordship, it's written evidence. Today, what evidence I have shown before the honorable court? He cannot, your lordship, he doesn't have any defense.
All right.
He cannot bring any further documents before the honorable
You are
court.
relying on this.
I am relying on this judgment, your lordship. Let me hear him, and then after, your lordship, I will show another judgment, your lordship, if it is required, that issuing a check is an admission of debt, your lordship, under section 18.
There is no doubt on it.
So if, your lordship, this particular document dated 23rd of March 2017 has
no
been
one
issued.
is disputing that there was a debt.
Yes, your lordship.
Debt is still there.
Yes.
Only it cannot be enforced. That is the point. Limitation means it cannot be enforced.
Enforced. No. If it is 23rd of March 2017, this particular check is issued on 23rd March of 2017, then, your lordship, it is within limitation.
Yes, what do you have to say?
If my learned friend wants to cite the judgment, he can cite so that I can deal with it one.
Yes.
Let's give him. This is well settled, your lordship, section 18. No, it's not. The issuance of the check is
What
an
is the other
admission.
judgment?
I'll give your lordship on before the next date, your lordship, I'll give.
Hard in part adjourned to आगे दाओ 18
18.
Great figures.
regular list, item number 1,
This has come at my instance, my lord, only for, my lord, rescheduling the date for, my lord, examination of the witness, my lord. If your lordship was pleased to, my lord, fix the date for examination of witness,
Who is the other side?
my lord, this is a uncontested matter, my lord.
Yes.
Probate matter, my lord. There is no other side. Your lordship was pleased to fix it on the 27th of March, my lord. Could it be any other date, my lord? Any day after 31st of March, my lord. I have some personal difficulty. Any date convenient to your lordship, my lord.
Witness action is postponed to
It will barely take, my lord, 5-7 minutes, my lord, only to solve it.
11th April.
Yes, my lord. I'm grateful, my lord. I'm so grateful.
item number 2 and 3,
I was making my
Mr. Lahiri, keep one thing in your mind. 3 holidays are forthcoming,
yes,
at least 10.
increase.
Of
decrease.
course not.
Why not? Holi is for celebration.
Celebration doesn't mean celebration of fat, obesity.
Food.
You will
India celebration is only by food.
Difficult by that.
He cannot be convinced.
Even I have been told by my doctor. Same figure. No, my lord, I was submitting what was the case which was made out in the plaint in the other suit, first suit,
Hmm.
their suit.
Ingredients of tenancy.
Ingredients of tenancy. Now, it was Mr. Lahiri's submission that he is not saying that. I have also shown, my lord, the evidence where he says, to my suggestion, no, he is a tenant under the Rent Act. So, my submission was that
Rent Act means here Premises Tenancy Act is of course not applicable under TP Act.
TP Act is not a Rent Act, my lord. When we talk,
Whatever the witness may say, witness is not an legal expert.
no, but it is his case. Today, his evidence exemplifies his plaint, explains his plaint. His case in the plaint is he is a monthly tenant. Now, Mr. Lahiri said, no, I am a tenant under section 106. Now, section 106, in my respectful submission, my lord, does not deal with tenancy as such.
Only determination of tenancy.
Only determination of a month-to-month lease or a year-to-year lease. It says that if the lease is to be taken,
What Mr. Lahiri says, it's a very kind of tenancy which is contemplated in section 106.
it is, I
Hey,
would,
এটাকে একটু use করো না।
I think, my lord, that is absolutely my right.
বেশি টেনো না, ছিঁড়ে যাবে। Yes.
Now, my lord, in these proceeding, I had filed a chapter 13 application
Yes.
and I had obtained a decree. That was set aside. Now, my lord, the appeal court's order records the case that was made out before the appeal court. And it says, my lord, if my lord takes the judge's brief of document, page 47.
I'm looking into this compilation.
Yes, my lord. I don't think it is there. It is in the judge's brief of document, page 47. Yes. My lord, this is a judgment and order dated 30th September 2011, passed by Justice Kollanjyoti Sengupta, sitting with Justice Jayamalla Bagchi, my lord. Well, it takes page 48, the first paragraph. Both the parties brought separate actions for their desired relief. The appellant before us had filed title suit number 5305 of 2008 in City Civil Code in and about December 2008, claiming for a declaratory decree that the appellant in the above suit is a monthly tenant under the respondent. That was their case, and that was the case on the basis whereof the decree that was passed set aside, that this has to be considered. The next page, my lord, again, the second paragraph.
According to the appellant,
according to the appellant. Before us, the said document talks about that 1st April 2004 document.
Substance
in
is in substance a
tenancy
tenancy.
agreement. So his case, and my lord, justifiably, because even under, if my lord knows that transfer of property does not offer the kind of defense which the Rent Act offers. Rent Act is far more technical,
Stringent.
far more stringent and far more technical. 6 or 7 grounds, only on that it can be granted.
In fact, you are tied down to certain grounds only.
Grounds only. I cannot say that as my lord had held in the other suit, my lord. Somebody questions my title. Under the Transfer of Property Act, I can throw him out. Under the Rent Act, I am not given that liberty.
Once terminated under Rent Act, you are a statutory tenant.
That is a different answer. Now, but on the broader issue, again, my lord, at page 51, the last paragraph, he submits in the affidavit that in the affidavit, strong tribal issues were raised as the case filed by the plaintiff in the High Court is based on leave and license. However, the act and conduct of the parties would suggest that it is a case of monthly tenancy. My lord, it has been the jurisprudence that under Chapter 13A, eviction can be granted where the defendant does not have a defense.
Obviously, it cannot be under statutory, especially West Bengal premises tenancy.
Cannot be under. So the whole case that was made out in the plaint is very specific. The plaint does not say I am a month-to-month lessee. So today he is entitled to that.
Where is the observation of the appellate court?
Yeah. "53 hours matter after having narrated the fact." In our view, and it is the second paragraph somewhere in the middle, my lord, starts with "in our view." It is the duty of the court before entertaining any lease in any form, whether substantive or interlocutory, the court is obliged to examine whether it has jurisdiction or power, whether raised or not. If the court is reminded of the party, the task becomes easier. Then, my lord, he proceeds to page 60, my lord, first paragraph, after the first 2 lines above. The language suggests that in a restricted way, no other idea or thought can be brought in to help the suitor by the court. We, in this case, held that the learned trial judge did not have the authority to entertain the application, going by the statement and averment made in the affidavit in support of summons, and while entertaining the application, the case of defense comes later, and it cannot be seen that unless the court gets an authority to examine the defense, if the court lacks jurisdiction, it cannot examine the matter. Even if we presume, last paragraph, my lord, that the learned trial judge did have power in relation to the suit, those issues raised therein are triable ones. Therefore, my lord, the court accepts that whether it is a monthly tenancy or not is a triable issue to be tried. So the case which he may get, the defendant in my suit comes, is that he is a monthly tenant. He does not, nowhere says that it's a month-to-month lease. And in fact, my lord, I will show one more judgment before I start dealing with the judgments he has shown. My lord, 1977 Supreme Court. Before that, my lord will kindly take Transfer of Property Act once.
Yes.
Section 107.
How made?
How? A lease of immovable property from year to year or for any term exceeding 1 year or reserving a yearly rent can be made only by a registered instrument. Now, admitted situation is this is not the agreement of 1st April 2004 is not a registered agreement. Whereas a lease of immovable property is where a lease of immovable property is made by a registered instrument, such instrument or whether there are more instruments than one, each instrument shall be executed by both lessor and lessee. Then, my lord, provided the state government may from time to time by notification of official direct the leases of immovable property other than leases from year to year or for a term exceeding 1 year or reserving yearly rent or any class of such leases may be made by an unregistered instrument or by an oral agreement without delivery of possession. This is not the case here, my lord. There is no such. And my lord, section now comes to section 105. So
So far as section 106 is concerned, 7 is concerned,
107 is concerned, my lord, our agreement is not a registered one.
registered agreement, and then what is the effect of an
Effect of a
unregistered agreement?
registered agreement would be
You
can be considered.
note one case, Park Street Properties Limited case.
I shall consider it.
Park Street Properties Private Limited versus Deepak Kumar Singh.
Now, my lord, I will rely on AIR 2000. I'm sorry, not 2000. 1977, Volume 4 SCC.
Take down the reference 2016-9 SCC 268.
268. My lord, I shall consider and
Next step,
yes, ma'am. I will just 324, my lord, I shall rely on.
Hmm.
Sorry, I
no issue.
missed a copy.
After finishing your argument, to come with the notes of
I
argument.
will
with these
include
judgments.
it.
Yes, Leela Ghosh. This is an old case.
Yes. Technician studio.
It was followed by Vishwani versus Chandrash Kumar Datta.
Yes. Paragraph 3, my lord. The contention of the appellant in this court also is that as the first respondent
That's the case of 53A.
53A, my lord, it said the case was, the stand was that although this is not an unregistered agreement, it is a lease exceeding 1 year for a period, for a particular period. My lord, that will appear from paragraph 1. It is claimed that this was a tenancy governed by the West Bengal Premises Tenancy Act, which protected them against eviction. This is not the case in our case. Now, paragraph 4, my lord, admittedly, there was an ejectment decree against the appellant before the completion of the compromise, before the petition of the compromise was filed in High Court. By the compromise, the decree was not set aside, but a lease for 16 years was sought to be created in favor of the appellant. Thus, whatever interest the appellant may have had in the property was extinguished after passing of the decree, even if they continued in possession after the decree. The subsequent possession, in order to be valid, must be referable to the compromise. Clearly, the petition.
Only do one thing.
Hmm.
Come with the notes of argument with all the list of judgments.
Yes, madam. I will.
So this I have gone through.
This matter, it says that it will be a void lease.
No, that is subsequently explained. Go through Park Street case.
Yes, madam.
Properties
I shall.
case.
And my lord, here also in the next paragraph. And my lord, now may I just point out two of his judgments, my lord. My case is that it is the document speaks for itself. It was a lease and it was a license for 5 years the document clearly provided that he is not entitled to, nor shall he claim exclusive possession. And my lord, it is also the settled law that mere exclusive possession is not sufficient to turn a license into a lease. Intention of the parties will have to be looked into. Now, most of the judgments, he had shown, my lord, 5 judgments, relied on 5 judgments. Now, most of the judgments are of a situation where it was being considered whether it's a license or a tenancy. Month-to-month lease or month-to-month tenancy as envisaged under section 106 was not the contention there. And one of the criteria which the honorable courts had adopted, courts have adopted, is that whether there was a conscious effort to avoid the rent legislation. Now, ex facie, the document reserves a monthly license fee of 45,000. This takes away the probability of application of the Rent Act in our case. Why Rent Act? As my lord, I had been submitting, and my lord knows that Rent Act is stringent. Rent Act gives the authority only to the honorable court to evict a particular tenant under certain grounds and no other grounds. Unlike Transfer Property Act, because under section 11A, 111A, there are grounds A to G, which occurring ipso facto, the person, the lessee is liable to be evicted. In addition, my lord, there is H, that if I have given a notice under section 106, then also I am entitled to evict. Now, 2 judgments, my lord, I shall specifically also rely on. My lord, one is Delta International, which is 1999, 4 Supreme Court cases 545.
This building,
Yes, my lord, here.
Ganariwal.
Yes.
Yes, I've seen this. These are old judgments.
Only thing
I used to heavily rely on
I'll
this.
just point out the.
You come with the notes of argument.
I will. I'll just point out.
Which paragraph you're referring to?
Yes, my lord. My lord, comes to paragraph 16. Is that page?
From the aforesaid discussion, what emerges is
To
559.
find out whether the document creates a lease or a license, the real test is to find out the intention of the parties, keeping in mind that in case where exclusive possession is given, the line between a lease and a license is very thin. Intention of the parties is to be gathered from the document. Mainly, the intention is to be gathered from the meaning of the words used in the document, except where it is alleged. My lord, I shall put emphasis here, my lord. Where it is alleged and proved that the document is a camouflage. If the terms of the document evidencing the agreement are not clear, surrounding circumstances may be looked into. Now, my lord, will come to paragraph 18. Here, my lord, it was held to be a license, not a lease or a tenancy. In our view, the submission of the learned counsel of the appellant request to be accepted, because as stated above, it is nowhere pleaded that the deed executed between the parties is a camouflage to evade rigors of the provisions of the Rent Act. Nor is it stated that it is a sham document is executed for achieving some other purpose. In these set of the terms, the intention of the parties is required to be gathered from the express words of the various terms of the document. Why not I rely on this part? In my case, in this case, there is also no pleading that it's a sham document. There cannot be such pleading because the license was taken at a monthly license fee of 45,000, which negates operation of the Rent Act. So the question of creating a camouflage does not arise. And the very fact that the document is for a period of 5 years and no one wanted it to be registered also shows that the parties did not intend to enter into a lease. So the only conclusion, my lord, can be that it was a license. My lord, even 19. And 21. 21 also comes to there whether it was to defeat a law. No contention was raised that the license deed is a camouflage to circumvent the provision of the law or to defeat the rights of the owner or the tenant who granted the
This
license.
is your argument in respect of their suit. So for
In my suit also. This is my argument that in our case, circumventing rent
so
tax,
your point is this is a case of license.
it's a case of license.
It expired.
Circumventing rent tax does not apply.
First thing. Second
thing.
thing, it's a license. It expired.
It expired.
And so he's
I
valid.
also have before expiry made him aware, because there was, I think, a renewal clause somewhere, or it was expressed somehow.
Did you accept rent after expiry? Did you accept rent after
No,
expiry?
no. The rent that was paid was under.
There is no holding over or like.
No. Unlike, my lord, the other case, my lord, this is just a moment. The other judgment he relied on, 2004 volume 3, the CM Bina case. 2004 volume 3 SCC. Page 595.
Yes.
Paragraph 8, my lord. Here also the same consideration. The crucial issue for determination is as to whether there is a lease or a license existing between the parties. Full stop. Though the deed of license may have been executed, it is open for the parties to the document to show that the relationship which was agreed upon by the parties and was really intended to be brought into existence was that of a landlord and tenant, though it was outwardly styled as a deed of license, to act as a camouflage on the rent control legislation. So, this has been the cardinal.
The conduct of the parties before and after the creation of the relationship.
Yes, my lord.
Is
Why, my lord, will find out.
Is of relevance for finding out their intention.
Yes.
So, intention of the parties are of paramount interest.
Yes.
Paramount importance.
Absolutely paramount. Unless someone alleges that the landlord wanted to avoid the rent act, therefore styled it as license. And my lord will also consider paragraph 10 and 11, where two other earlier British, where the British law has been set out. Paragraph 11 particularly says,
Addis Company Garden Limited versus Crab. That's what is judgment given by possibly Lord Denning.
Yes, my lord.
There, this point was very well expounded.
Yes, my lord. It says, my lord, paragraph 11, somewhere in the middle, at the next page. However, the fact that exclusive possession is granted, though by no means decisive, as distinct from a tenancy, is at all events a consideration. Further, grant of exclusive possession may only be a license and not a lease, where the grantor has no power to grant lease. And then, my lord, the facts of this case is set out in paragraph 12, which was the deciding factor. On facts found by two courts below, which findings have not been reversed by the High Court, it is clear that the nature of the premises is a shop, not a garage, meant and designed exclusively for parking a car. Here, my lord, it is just a basement. The premises are located in a busy commercial market. The appellant has exclusive possession of the premises, and the owner neither can nor does interfere therein. Here, there is a clause that you are not in exclusive possession. Then, my lord, a full-fledged stationery shop and allied business activities have been carried on since 1972. The appellant was in possession of the premises for about 20 years before the date of deed of license. And in spite of the deed of license of 1981 having been executed, continued to possess. And in fact, my lord, here it is said that though the next line, my lord, that though the so-called license expired in 1982, the respondent did not insist that the appellant on the appellant putting back respondent in possession and allowed him to remain in occupation for a period of about 7 years. Well, these were the deciding factors. Here, my lord, as soon as the period is about to come to an end, I write a letter. My lord, that is Exhibit F. I have given him a letter that your license
The security deposit was adjusted against
the security
subsequent
deposit is
3 months or 4 months possible.
6 months security deposit, which is why from October I stopped taking rent because I was adjusting. Now that itself was an indication
Then I'm about to terminate you.
that I am not going to continue the permission anymore.
There will be no scope for renewal.
No scope for renewal. I also write a letter to him. My lord will consider Exhibit F. Exhibit F, my lord will also consider in the line of section 106 that assuming but not admitting, my lord, assuming that this can be called a month-to-month tenancy, it was terminable with 15 days notice, and I have given him a notice.
All right, come on the next day, finish your argument and find
Next
the
day,
notes
my
of
lord, I
argument.
shall start with the other more nagging issue.
Which one?
Who are the parties to the agreement?
Oh, GUI.
We or GOI? So on the first point, my lord, which I think more or less I have
Finished. But your notes of argument must be
I
there
will.
with the compilation of
I will.
judgments. Heard in part adjourned to মার্চের লাস্ট উইক দেখো 26
My lord, 27th,
26, 27, my lord, I have got fixed matter.
then in April
28th.
28 should have.
no not 28 1st April
Second.
you will not be fooled, I will not be fooled,
First April.
but I may be fooled by Mr. Lahiri, that I can assure.
Very well, my lord.
First
First April. Let us not be superstitious.
All right, 2nd April second ঠিক আছে নাকি হবে?
Second is a very auspicious date.
Why? Why?
Wife's birthday. Yes.
Item number 4.
Calls for a party.
You committed a mistake.
No, but he is not capable to get me to a party.
This is a
Yes.
testamentary proceeding, mother.
Who is your other side?
I am appearing on behalf of the defendant, your lord.
The midst of the argument,
Hmm.
the defendant was the caveator. He was arguing Mr. Shubhashish. Sengupta. Mr. Sengupta, the caveator had finished on the factual aspect, had taken the court to the
Notes of
deposition.
argument?
Yes,
your
that's
lordship. My lord, I need some more time to prepare it, your lordship.
After notes of argument will start.
I can give you the brief idea, Malad. Notes on argument, and only thing he will give me the judgments he must rely upon.
Yes, your lord.
That he has not yet given. I must be candid, Malad. He has not. He
Mr.
is,
Sengupta came to this court for argument.
yes, in the morning he was there.
No, not morning. Why not?
I know in the first matter, not the morning, the first matter in the commercial side. Now he told me that so far the judgments are concerned, he will give me the judgments. Now the testamentary proceeding, Malad, appear for the propounder. The will is of my mother. I am the son. I am the only son, and challenged by my sister. Father predeceased, so mother left behind a will. Ancestral property of my father's property, our residential house, is subject matter of the probate proceeding. Under the will, my mother gave this property to me. That is the thing. And so far the movables are concerned, the affidavits prove that the lady, my sister, at the time of her marriage, whatever ornaments and the evidence are there, whatever ornaments and other things are required, she has been given. My father was a ex-government employee. Now, after her death, there was a family pension scheme because she was a divorcee, my sister. So she's entitled to the family pension. Whatever documents in connection with family pension, the family pension book and other things, my client had already given it to her and she had made necessary applications to the authorities. So compliance on my client's part is over. As far as I understand that this process are going on, she will get the family pension of my father's pension. Her allegation is, in the affidavit in support of caveat, is the standard allegations of coercion, undue influence, fraud. He says testamentary capacity. Now, there is no document produced by my learned friend, by the defendant, in support of its allegations. She came in the box and gave evidence. Now, what I understand from the argument, the main thrust of the argument is, so from my side, 3 witnesses were there. One is the attesting witness, the will is
Witness evidence was
the
issues were
first-
framed.
the issues have been, yes, the testamentary capacity.
Issues bar karo. In number of cases, I have found that contested
yes,
matters,
I have seen.
issues are not there.
Not there and may require recasting at like
আগে ইস্যুটা দাও, ইস্যুটা দেখে নি আমি।
ছিল।
Oh, these issues were cast by me, framed by me. Now evidence টা দাও।
In support,
Evidence, testimony.
testimony evidence and now she will kindly give the will also.
Who is PW? This is
PW1, yes. PW1 is
Who is PW1?
Yes, Shukumar Banerjee, attesting witness to the will. PW1.
He is PW1.
PW1, Shukumar Banerjee is attesting witness to the will. Second, I'll just tell you in brief manner, the second witness is the advocate,
Mr. Mondal.
Mr. Mondo. And the third witness is the propounder himself, the cat. Now, so far PW1 is concerned, if I take your lordship to the evidence of PW1, he is a resident, in a neighbor to the testatrix in Modhamgram. Now, question number 7, 8, 9, the document was shown to him. Question 10, the original will was shown. Question 11, he starts identifying the signatures. Now, question 12, 13, 14 are these all with regard to the signature? I'll just place my lord. Question 12, the signature on the first page of the Rita Mukherjee, alias Chanda Mukherjee. Second page, signatures. 14, he signed in front of me. Who is this? Ranjit Bonik is the second witness. He was present at the room. Rita Ranjit signed on this document. Rita was also present in that room. He saw both of us signing this document. Where was Ranjit when you signed this document? Ranjit was also present in that room when I signed the document. 18. When Rita signed in the first and second page, where were you? I was present at that room when Rita signed on the first and second page. Where was Ranjit? He was also present there. Then witness encircles the signature. 21. And then the will is marked as Exhibit A. The signatures of Rita, Exhibit A by 1 series. Ranjit, and these are marked as exhibits. The original will is produced. So up to 21 is the execution of the will in the presence of both the witnesses. From question number 8 to 21. Now 22 is important, my lord. Other than Rita Mukherjee, Ranjit Bonik and yourself, was any other person present at the time of execution of the will? Yes. One person was present. I do not know his name. He was helping us to sign this document. When did Rita Mukherjee tell you about the execution of the will? Some days before the execution, Rita Mukherjee told me about this will. Do you recollect the time around when this execution took place? At around 8 AM, the execution
9 AM.
9 AM, sorry, 9 AM, sorry. 9 AM, the execution of the will took place. In which place did the execution happen? At the room of Rita Mukherjee, the execution of the will happened. So the place. Date. Question 26, 19th of December. 27 onwards is the question that he inquired about the will. 28, what was the answer? I asked her about the second person and why, when the question is gone, whatever. and why she had not given the property to her daughter and had given to his son. She replied that her daughter was married to a rich person who is also resident in the neighborhood and is in a promoting business. She, along with the husband, had given her property to her son and the immovable property like jewelry, etc., to the daughter. What was the mental and physical condition of Rita Mukherjee? She was completely healthy, both physically and mentally. The will was executed by Rita out of free will. Now, there's a difference of Rita and Chanda. Now, she 31, she clarifies it. We know about his name, Chanda Mukherjee, as the same appears in the voters list. The name Rita Mukherjee was a maiden name because she had signed in both. Now, question, because this is important, the timing, because my learned friend has taken this issue as one of the main issues. Question 34.
35, 34.
Yes. Kindly see page 10 of the probate application where it is written that the will was executed at 10:30 a.m. on 19th of December. Am I right? Yes, that is so. In answer to question 24, we have said that the execution of the will took place at 9 a.m. Are you in a position to clarify this? On that date, I was present there from 9 a.m. The signature and execution was made at 10:30 a.m. Kindly see your answer to question 28, where you have referred to about a second person. What do you mean by second person? By the second person, I mean the elder sister of the petitioner. To quote, what is the name of the petitioner? It is nickname Raja Mukherjee, examination concluded. Raja is the propounder's nickname because they are neighbors. Now in the cross-examination, my lord, he says that we stay in Nandan Kanon. 42. Who told you to put your signature on the alleged will of Rita Mukherjee? Rita Mukherjee had herself asked me to put my signature on the will. 43. Before signing the will, did you read? Yes, I had read the will at the time, but now I cannot recollect all the contents of the will as it is an old will. Now 44. You have deposed to have reached Nandan Kanon, that post office at Madhamgram, at around 9 a.m. and the execution at 10:30. Am I correct? Yes, that is so. Who were the persons present? These are in cross-examination. At the execution of the will, there were 4 persons present. Rita Mukherjee, at the time of execution of the will, one Rita Mukherjee, another person was an advocate, as Rita Mukherjee told me earlier, myself, and there was another witness. I do not remember his name right now. Are you aware of any person by the name Ranjit Bonik? Yes. What was the age of Rita Mukherjee? It was difficult to me to know the exact age. 48 with regard to the health condition of Rita Mukherjee. 49. Can you indicate what happened after the signature was done? After this date, once or twice, I had asked her about the will. We had a few talks during that time. Did Rita Mukherjee tell you about the registration of the will? No. Immediately after the execution of the alleged will, what was the discussion between you and Rita Mukherjee? After execution of the will, I just had a talk about her health condition. I suggest you that you left the premises at around 1 o'clock on that day. Not a fact. At what time did you leave the residence of Rita Mukherjee on that day? At around 11:30, I left the residence of Rita Mukherjee. Can you tell how much it usually takes from Madhamgram to High Court? I cannot say this, as my office is at Jivandip. I usually travel to office by metro. I suggest to you that the alleged will of Rita Mukherjee was presented before the registration office at 11 a.m. on that date. I do not know. So this, and the rest of the questions, my lord, is what the other questions are 40, 57 and all, that who signed first. These are all came in cross-examination. 57, 60 with regard to the name of Rita Mukherjee in the voter list, the other name. 59, 60 with regard to this. Now this is not a defense that this is somebody else's will. That is not the defense. Now the relationships.
What is the defense case?
Yes, the defense case.
Written statement of the case.
The defense case. The defense case is the first 9 paragraphs are with regard to the matrimonial problem of the lady, of my sister. First 9 paragraphs of the affidavit. That he admits that he was married in 1993. He had 2 sons. He admits that his brother is a government employee. Now, paragraph 9 is her matrimonial problem and criminal proceedings as a result. Brother never supported, paragraph 9. Now, what is important in paragraph 9 also,
Fabricated, manufactured.
yes, now one thing, but paragraph 9, he admits that, see, now the question from the box, he said that I've been divorcee, so I need a means to stay. But in paragraph 9, she admits that he has been paid 30 lakhs by her husband. And he
3
also,
lakhs.
30 lakhs in paragraph 9.
Yes, give me 30 lakhs.
Yes. And he also admits in the
We are not concerned with that.
Yes,
The probate
we are not concerned,
proceeding,
we are not concerned.
para 14 is the defense.
Yes, minor. Paragraph 14,
Forgery, fabrication, and
forgery,
manufacture.
fabrication, manufacture, and not free consent. Paragraph 14. And then no testamentary. So forgery, fabrication, manufactured without free consent, no testamentary capacity. So these are the 5 points. Now on this, I say, Malar, I respectfully submit, Malar, with regard to forged, fabricated, manufactured, even free consent, the onus is on the person who is espousing this cause, the caveat.
In fact, both are contradictory. When you say there was no free consent, that means the person was present. Her or his mind was absent.
His mind was absent.
When you say forgery, both were absent.
Both were absent. Yes, both were absent. Then it's like, it's not her signature. Then I'm questioning the signature is forgery. This is not the signature. Then that becomes forgery. The will manufactured after death or whatever. So then it comes
Challenge
to
on this ground, fabrication,
yes.
forgery,
Challenge on this ground.
this is a
Now-
manufactured will.
Yes. Now paragraph 16 also says, had not executed by her, and my brother had managed to get the signatures of the alleged attesting witnesses on the purported document. So it's a case of manufacture. Forgery and manufacture. Basically, it was a manufacture. Now, on this, my first witness has gave evidence with regard to the execution. Because I have to satisfy the court, my lord, with regard to 63 and 68 of the succession and the evidence. So with regard to execution of the will, this is my evidence. Now, this gentleman has said the main issue in the argument was that if the will is executed at 10:30 at Modhamgram, how can the will be presented for registration at RA office in across Rajbhavan at 11:30? This is the main thrust of that. Now, my second witness is the advocate. The advocate who has filed the probate proceeding and who was present at the time of execution of the will. He is not a attesting witness, but he was present.
This I've seen his witness.
Yes. He has said that, and lordship has been taken through this witness. So he has said the execution of the will took place around 10:20, 10:25. Now, I'll cite a decision, Mala. In a probate proceeding, the execution. Now, in any event, the will is of 2009. Today we are when the witnesses are on the box 2024. Now,
Reliability of memory.
so no, you cannot remember whether it's 10:20 or 10:25 or it is 10:26. Yes, you can always remember early morning, evening. If I ask you the color of your shirt on that day, where was the paint of the room, it is impossible for the human being. And moreover, when I have nothing to do with the probate proceeding, a neighbor, an elderly lady requested me to sign on the will. Why should I? It has nothing to do with me. I'm not neither beneficiary, nothing. So why should I remember? End of the day. So that's also plays in human mind. Now, there's one decision of Supreme Court says that I need not prove it every second or the execution. The entire execution process has to be proved. And it's the duty of the defendant who is alleging fraud and this that I was not present at that time. The testator or the testatrix was not there. The will was done later. So my second witness, who is the advocate of this honorable court,
Who is PW3?
is the propounder. Is the propounder of the will.
He was present?
No, he was not present. The propounder was not present.
Who was the propounder?
The son, the executor, the son. The son was not present. So and the few questions here, Manat, my second witness all along said he was present over there, and he accompanied
Mr. Mondal was PW2.
Yes, he accompanied the lady from Modhamgram by a car and reached RA Calcutta, and then he was the person who conducted the
Let me see the evidence of DW1.
DW. DW1. Now,
এই এটাকে ঠিক করে অ্যারেঞ্জ করো, আগে পরে যেখানে ইচ্ছে যেটাকে বুঝেছো পরপর অ্যারেঞ্জ করো প্রথম থেকে শেষ পর্যন্ত। Burden of proof is on the of the caveator or caveatrix.
caveatrix.
Fraud, misrepresentation, undue influence,
Forged everything.
forgery.
Forgery. That's the reason I opened by saying documents in support and the oral evidence. There is no document in support. So it all depends on the oral evidence. I'll just show. It's a registered will. Now, my lord, if we start the questions from 4 onwards, he admits the marriage, whatever the relationship. Now, in question 11, he says that he even did not participate in his father's last rites. Question 12 onwards, with regard to that provident fund issue which he got, it is not that he was given nothing. Now, question 15, that he has alleged that he was never allowed to meet her mother. He admits that there was no, I was threatened, I will be thrown out of the house. There is no police complaint. Question 22, answer to the court's query, my lord. In 2010, once he allowed me to meet her. Mother's education qualification is question 29. She was in a pre-graduate, I believe, a pre-university stage.
That is not relevant.
That is not relevant, Mother. That's just once I'm going through the questions, Mother.
92.
State will is, yes. So this is by mere saying it won't prove it. Now 90 will also, my lord, the question is, have you seen the purported will of your mother which has been filed before this court? He says no. So even on this day when he's in the box, the lady says that she has not seen the will. The approximate distance is only on that. How can somebody come from Modhamgram to Calcutta in Dalhousie in 1 hour? Had your mother ever discussed about the will? Never, she did not, and it's concluded in 97. And he has said in the chief that there is a brother never allowed her to meet. So in 61, he said there is no police complaint. And he has not attempted also to meet her mother. '61, '62, there's fight, and he admits that the pension book and the pension order is given to her. Those are marked, my lord. Though these are photocopies, but we didn't object, my lord. So I say, my lord, there is nothing, no evidence to establish the fact that the will is forged or manufactured, because it absolutely proceeded on the fact that the father's family pension book and other things.
Now, 120, it is said she was misguided. Her mind was misdirected. Forced coercion. These two defenses are contradictory.
120, my lord, this is in suggestion. This is in the cross-examination. There is a positive proof in support in chief. Because I had asked those suggestions because the defense is taken. It is unusual that immediately
It was also executed by force.
So these,
Fabrication and exertion of force or coercion are two contradictory things.
and I cannot dispel that unless you prove that. Unless the fact is proved.
And possibly the signature was identified.
Yes, that I'll take you to the will. Or she will see the will. Or she will see
118, question number.
So I take it the signature of Chanda Mukherjee appearing, it appears to be so. It is not said that is not the mother's signature. It's only bare statements has been made forged, manufactured. So for that, to prove that, he will have to bring undisputed signature.
Thing, Mr. Shengupta, I will want to hear from Mr. Shengupta. The case in the affidavit is that it is forged and manufactured. That means there is no genuine signature. And now she identified the genuine signature. If she comes forward and say she was misguided, the testatrix was misguided, mind was misdirected, then the defense or evidence is adduced just contradictory or going beyond the pale of the written statement, whether that evidence is permissible or not.
It can't be, cannot beyond pleadings.
Pleading is one, and adducing evidence is another. Of course, it is answered in cross-examination, not evidence.
Yes, not answered in cross. Answered in.
Come on the next date.
Yes. I'll just take you through the Mr. Mondol's witness, because one question has been put that after that day, what did you do?
I put Mr. Mondol here?
Yes, yes, important. Important. And I'll cross-examine him. Hostile declaring as hostile.
Ardin part. Adjourn to what a date bolo? 31st মার্চ ছুটি থাকবে আগে করো না মার্চের একটা আগে ডেট দাও 25th March is okay?
25th March, yes. Oh my, 25th March, city court job. Sorry.
26?
26, yes.
26th March.
Getting it. Yes. I get it, Chinese.
Witness some item number 5.
Who is the plaintiff?
The
Plaintiff's witness action is over.
DW.
Now DW.
DW will
Your
start.
witness is present.
Yes.
Will start.
Issues are there?
Yes, your lordship is recast has framed the issues. May I put my witness in the box? Yes, sir. না না ওনার সাক্ষী শুরু হয়নি আজকে শুরু হবে ফার্স্ট
DW1.
I solemnly affirm that whatever I depose by way of evidence, I shall speak the truth. No part of it shall be false, and I shall not conceal anything. Show me Banerjee. MIBANERJI. Late Dr. Probir Kumar Banerjee is my husband's name. 56 years. $56 years. I'm a homemaker and also a consultant. (27B) Roland Road, Kolkata 7,20,000. ROWLAND, Roland Road, Kolkata 20.
What is your connection with the present suit?
I'm the defendant number 1A in this present suit.
How are you related to the deceased?
I'm the daughter-in-law of the deceased, Dr. Probir Kumar Banerjee. Son of the deceased was the original defendant in this case. And after his death in 2018, March 13th, I was substituted 18.
March 2018 লিখলে ভালো হয়
I was substituted in his place along with defendants 1B, 1C, and 1D.
Who are the defendants number 1B and 1C?
Defendant 1B is Miss Preeta Banerjee. She's the Miss Preeta Banerjee. Preeta, PREETA BANERJI, Preeta Banerjee, daughter of Dr. Probir Kumar Banerjee from his previous marriage. Defendant 1C is Mr. Deep Banerjee, son of DWP, BANERJI, son of Dr. Probir Kumar Banerjee from his previous marriage.
Who is the defendant number 1D in this proceeding?
1D is Mrs. Onima Banerjee, mother of Dr. Probir Kumar Banerjee,
হাতে হেভি ব্যথা আর ওর কানে
and widow of the deceased.
Deceased testator.
She passed away in June 2020.
Do you know the plaintiffs?
Yes,
Do you know the plaintiffs in this suit?
yes, I know the plaintiffs in this suit. They are my brothers-in-law, also sons-in-law of 3 of the daughters of the deceased.
Who were the persons who comprised the family of the deceased testator on the date of his death?
On the date of his death, he was survived by his wife, Srimati Onima Banerjee, son, Dr. Probir Kumar Banerjee, and 5 daughters, being Mrs. Archana Mukherjee, Mrs. Chandana Chatterjee, Mrs. Ranjana Chakraborty, Mrs. Malavika Ganguly, and Mrs. Oli Gangopadhyay. Oli Gangopadhyay.
Were any of the daughters of the deceased testator residents of Kolkata?
Yes. My eldest sister-in-law and the daughter of the deceased, Mrs. Archana Mukherjee, resided in Kolkata.
Instead of deceased, say testator.
Deceased testator resided in Kolkata while the others were outside Kolkata.
In what connection did you first meet Dr. Probir Kumar Banerjee, and when?
I was a banker by profession, and I was working with Standard Chartered Bank, erstwhile ANZ Greenlays Bank, ANZ Greenlays Bank. And in 2001, I was posted at the Godihat branch of Standard Chartered Bank, where Dr. Probir Kumar Banerjee and his previous wife, Mrs. Chitra Banerjee, were customers of the branch. In my professional capacity, I met them for the first time in 2001.
Were you acquainted with the defendants number 1B and 1C prior to your marriage with Dr. Probir Kumar Banerjee?
Yes, I met the defendant number 1B and 1 prior to my marriage. Dr. Probir Kumar Banerjee's previous wife, Mrs. Chitra Banerjee, passed away in 2004 July. After that, defendant 1B and 1C, being her children, they visited me in my branch at Standard Chartered Godihat with regards to encashing their deposits. Encashing their fixed deposits. That is how I met them for the first time.
Since when? Where was the testator? No. What was the usual place of residence of the testator?
The usual place of residence of the testator was in Patna. Intermittently, he would come to Kolkata. However, after the death of Mrs. Chitra Banerjee in 2004, the testator and his wife moved in with their son, Dr. Probir Kumar Banerjee, into his Roland Road residence, in Kolkata.
Are you aware of the general state of health of the deceased testator?
Yes, he was, to my knowledge, yes, he was ailing and he was also aged, which required frequent medical intervention.
Who
Frequent medical?
who arranged for such medical treatment of the deceased testator?
My husband, Dr. Probir Kumar Banerjee, arranged for the medical needs of the testator.
When did you first meet the testator?
In late 2006, Dr. Probir Kumar Banerjee had invited me along with a couple of his friends to tea at his Roland Road residence. That is where I met the testator and his wife for the first time. The testator and his wife for the first time.
Was that the only occasion, or did you continue to meet the deceased?
I met him after that also a few times. And in one such meeting, I remember the testator and his wife proposed marriage between their son and myself. The testator and his wife, being aged, and the fact that Dr. Probir Banerjee's wife had passed,
Be slow.
sorry, having passed away, and both his children not residing in Kolkata, they strongly wished that their son remarry and settle down. Remarry and settle down.
Did you accept the said proposal? Did you accept the said proposal?
I was taken aback as I did not know Dr. Probir Kumar Banerjee very well personally. I was taken aback as I did not know Dr. Probir Kumar Banerjee personally very well. And also, I was the sole caregiver for my 81-year-old mother who lived with me in Kolkata. She was at that point in time, my mother was suffering from Alzheimer's disease, which was at an advanced stage. At an advanced stage.
Where were you located in January 2007?
In January 2007, I was posted in Hyderabad for work. which lasted until October 2007 for work. It lasted until October 2007.
Did you reacquaint yourself with Dr. Probir Kumar Banerjee after returning to Kolkata in October 2007?
Yes, I did reconnect with Dr. Probir Banerjee on my return from Hyderabad. And thereafter, we started meeting a few times. And the marriage proposal was again renewed by Dr. Probir Banerjee and his parents. This time, with the encouragement of our Guruji, and the support of my family, I accepted the proposal.
Yes, stop here today, Manoj. I'll come back.
DW1 is examined in chief in part. Full stop. Further examination in chief is deferred to 4th April. 4th April.
Can it be 5th April, Manoj? Can it be 5th?
5th.
5th.
No, 5th is Saturday.
Saturday. 7th in that case.
9th.
Very good. Obliged. Your Lordship.
Item number 6.
In this matter, the witness has recently undergone the eye surgery.
Adjournment.
So today the
How long?
adjournment, first week of April, as your lordship's convenience.
Witness action is adjourned to 2nd week. I'm making it 2nd week. देखो 2nd week है. Sixteen, 17 days. 2nd week है देखो 10, 11. 11.
11th, yes.
11.
Grateful lordship.
7.
I'm for the petition, my lord. My witness is present.
Attesting witness or propounder?
Propounder, my lord. On the last occasion, a attesting witness was examined, my lord, and there is a
Will is exhibited.
yes, my lord. There is a typographical error.
Make it correction. Correct it. And death certificate? You must
will be
produce the
tendered
death
today, my lord.
certificate.
It
Yes.
will be tendered today. Prashant.
আমি শপথপূর্বক বলছি
এই মামলায় সাক্ষ্য দিয়েছে।
এই মামলা সাক্ষ্য দিতেছে এই মামলা সাক্ষ্য যা বলিব সত্য বলিব সত্য বলিব মিথ্যা বলিব না কোনো কথা গোপন করব প্রদীপ কুমার খা এই যে সত্য প্রসন্ন খা
এটা দাও।
আইপ্যাডটাকে দেন।
সত্য প্রসন্ন খান আমার বয়স 71 আমি প্রাইভেট অফিসে চাকরি করি
Presently you are employed.
presently I am also working 25B Tough Road
Tarf Road. TURF. Tarf Road.
Bhawanipur Kolkata 73025 25
কি নাম হতো? Khan, Mr. Khan.
Take all these things back.
The Aadhaar card must have.
Put it in your pocket.
হ্যাঁ পকেটে নিয়ে নিন। ফেলে চলে যাবেন আবার এনে put it in your pocket. Mr. Khan, how are you connected with the instant testamentary proceeding?
I am the sole executor of the will and testament of my father, Satyaprashanna Khan. And this PLA has been filed in my instance.
My instance. When did your father die?
My father died on 24th of April 2004.
I'm showing you the original document, annexure আছে না? which is probate application, which is annexure A to the application for grant of probate. Kindly tell the honorable court, what is this document?
This is a death certificate of my father, Satyaprashanna Khan.
Is it original or copy?
It's original.
Mark it.
Mark. E হয়েছিল E হবে E for England. Prior to the death of your father, where he used to reside?
He used to reside at our ancestral residence at Amta in the district of Howrah.
At the time of your father's death, who were the legal heirs?
Myself, my mother. I am the only son, my mother, and three married daughters.
Where your married daughters used to reside at the time of your father's death?
They used
Married
to
daughters or married sisters?
Sorry. Sisters. Father's death.
They are all married and they resided in their matrimonial residence.
Which place?
Which place?
It is place one sister at Naktola and one sister at Noida, UP, and one sister in Chingrigata. Yes.
Is your mother alive?
No, উনি মারা গেছেন।
When did she die?
She died on 4th March 2020.
I'm showing you a document. Kindly tell the honorable court, what is this document? Is Xerox আছে?
যেটা বলতে আছে। It is the death certificate of my mother in original.
And this is the original document, original land. And may the mother's death certificate be marked as an exhibit.
Original?
Is original. Yes, original. Yes. Where do you reside?
In Calcutta.
Which is your place of residence?
Is my place of residence.
Which is your place of residence?
Address.
Place of residence in Kolkata, Bhawanipur.
Address.
What is the address?
Address.
25B Taft Road. 25B Taft Road, Bhawanipur, Kolkata 73025.
Since when are you residing at this address?
I am residing for last 17 years.
Do you visit your ancestral house at Amta?
Yes.
How often?
আমার বাবা মা যখন বেঁচে ছিলেন তখন আমি মাসে অ্যাটলিস্ট দুবার যেতাম।
Where did you live prior to leaving this Bhawanipur address?
In the, nearby in our same locality, in a
Another house.
in a tenanted house.
What is the address?
7 Madan Pal Lane, Kolkata 25.
Bhawanipur. 2025 all Bhawanipur.
I know.
Pin codes. All Bhawanipur pin codes 2025. What was the source of income of your father?
My father service করতেন post office.
After the death of your father, who used to look after the ancestral properties at Amta?
After the death of father, I am still looking after. Till today, I am looking after the ancestral property of my father.
When did you come to know that your father has executed a will?
আমি হোলির সময় in the March of March 19 আমি আমার ancestral residence এ গিয়েছিলাম। March 19.
না সেটা জিজ্ঞেস করো ভাই ধরা বললো 19
2019
হ্যাঁ Then what happened when you visited the ancestral house in March 2019?
তো ওই সময় আমার মা আমাকে আমার বাবার উইলটা হ্যান্ড ওভার করেছিলেন। উনি এও বলেছিলেন যে উইলটা বাবা মারা যাওয়ার পর থেকে আমার কাছে আছে। এবার এখনো স্টিল ওই সময় অবধি ওনার কাছে ছিল।
After coming to know about the existence of your father's will, what steps did you take?
আমি ওটা নিয়ে কলকাতায় এলাম। কলকাতায় স্বপন কুমার আশ এক অ্যাডভোকেট ছিল, ওনার কাছে আমি নিয়ে যাই উইলটা। কুমার আশ ওনাকে আমি উইলটা দেখাই। উনি আমাকে অ্যাডভাইস করলেন যে এটা আপনি প্রোবেট অ্যাপ্লিকেশন করুন। তারপর উনি সব করেছিলেন যা করার ছিল।
All the permanent properties they cover. Are you aware of any person by the name Shambhu Nath Khotial?
Shambhunath Khotial is a compounder.
Is it?
Compounder. And he also attesting witness of my father's will and testament.
Testament. Are you aware of any person by the name Sheikh Munnaf? Munnaf.
Sheikh Munnaf is a caretaker of our ancestral residence. At least 25 years.
At least for 25 years.
For 20. For
And he is also a attesting witness of my father's will and testament.
Did you ever inform your sisters about the will executed by your father after coming to know of the existence of the will?
যখন আমি মার্চ 19-এ অ্যানচেস্টারাল রেসিডেন্সে গিয়েছিলাম, মা বলেছিল যে আমি তোমার সিস্টারদের সাথে অলরেডি কথা বলেছি।
Informed discussions.
And they have no objection. কিন্তু ওরা বলেছিল যে কোর্টের হ্যাপা আমরা নিতে পারবো না।
Formality.
Legal hassles.
Legal hassles. ঠিক হবে না ঠিক to undergo whatever জানি legal hassles.
কিন্তু আমাদের কনসেন্ট রইল।
Probate application এ দেখিয়ে দিত চোখে দেখিয়ে I'm showing you the page 10 of the application for grant of probate. Are you in a position to identify the signatures appearing thereat?
Advocate Sopon Kumaras on the top. Then down portion is my signature. Pradeep Kumar Khan. And it is dated
Pradeep, P-R-A-D-I-P, Pradeep Kumar Khan.
dated 16th January 2020.
Shown the affidavit of asset. কার কোনটা পড়ে সেটাও জেনে shown the affidavit of asset. Kindly, are you in a position to identify the signature appearing thereat?
It is my signature, Pradeep Kumar Khan.
Are the contents of the affidavit of asset true and correct?
It is correct.
What else do you prove? Death certificate is there.
Death certificate, mother had given an NOC, but thereafter mother expired. So we have exhibited
that.
Yes. Mother's death certificate is exhibited. The will is already exhibited. Now the
Then leave it.
execution is proved.
It is not contested matter.
It is not a contested.
Leave it.
Well, oblige. Cherry. Joseph.
TW2 is examined in chief in full and discharged. Any other witness?
No. Oh, well, there is one correction in the last day's deposition.
Make correction. That is not issue.
Seat a D হবে এটাও সি হয়ে গেছে এটাও সি হয়ে গেছে কারেকশন করে দিই ও কারেকশন করে দিয়েছে ইজ করেক্ট অলরেডি ডান
একটা ডেট বলো, আর্গুমেন্ট হবে। আমাকে ডায়েরিটা দাও তো। টোয়েন্টি মার্চ তো হালকা আছে।
25th March, but I have
Oh no, you'll go to
yes,
city
I have a
court.
problem 25th. Any day other than 25th.
28 March?
28th March, yes, yes, is the Friday.
Friday, 28 March.
28 March. Argument. Oblige.
Item number 8.
Item number 8. Last order কি ছিল?
Justin Conrad Nagel. Witness action, item number 8.
None appears. Adjourn to 16th April.
Nine. Item
I am
number
for the
9.
petitioner, my lord. The bond has been already executed in the present. The bond has already been executed, my lord.
Statement of accounts?
Yes.
Is it filed or not? এটা অ্যালাউ হয়ে গেছিল GA4? এটা আসলে GA4 এ কি অসুবিধা আছে?
All process are complete, my lord.
GA4 was disposed of. Report was called for.
Yes, ma'am.
No steps were taken for execution of bond.
Bond has already completed, my lord.
Report shows the otherwise.
In presence of the
He
commissioner, my
requested the parties to make necessary arrangement for execution of bond, and in spite of communication, the learned advocate on record took no steps for making necessary arrangement for execution of bond.
lord. Last week it is completed
Check
by
it
my
whether bond was executed or not.
Then I was present, my lord. I went to the petitioner address, my lord. Salt Lake.
No, the report is something else. You say bond was executed, but report is something else. See the report. Adjourn to 1st April. দাঁড়াও 1st April Tuesday. Testamentary আছে। GA4 shall not appear in the list. GA4 কে দিচ্ছে কেন? Since it was disposed of. ওটা লিখে নাও। GA4 shall not appear in the list since it was disposed of.
Next date is
Come on the next date.
February তে গিয়েছিল।
চেক করে দেবে।
February তে গিয়েছিল।
Oh.
February মাসে গিয়েছিল। দেখুন only C.
ওটা চেক করে এনে দাও ফার্দার রিপোর্ট further report is called for from the landed register original site on execution of bond.
10.
I am appearing on behalf of the plaintiff.
Your Lordship, this is an amendment application. May I only give the background in a nutshell? Your Lordship, formally this application amendment of a probate application. Your Lordship,
Probate application,
Your Lordship,
asset, you say asset.
not assets, Your Lordship. I'll apprise Your Lordship.
Where are the proposed amendments?
The proposed amendment is at page 93. 93 onwards. But Your Lordship,
The
perhaps
department will not accept this.
Your Lordship,
Department will not accept this unless this is done in grading. That will create a problem.
no, Your Lordship, I will apprise Your Lordships why it is in greening. Kindly allows me, Your Lordship. Your Lordship, after this probate application was filed, the executor had passed away. There were two named executors. One was the wife of the testator and the other was the son of the testator. The wife predeceased, the son expired after filing this probate application. Now, thereafter, Your Lordship, an application was taken out for converting the probate application into an application for letters of administration, which was allowed. Your Lordship kindly comes to the order at page 34, Your Lordship. 6th February 2020, this application for conversion was allowed.
34.
Yes, Your Lordship.
Yes.
Now, Your Lordship, what happened was this application was allowed and there were some legatees who had passed away. So also amendment to bring in the heirs of the legatees. So there were 2 or 3 applications back to back made, but none of those amendments were unfortunately given effect to. Why I tell Your Lordship? Because
Order was passed.
Orders were passed. All the orders are on record in this application. Now what happened was, after the amendment was allowed, Your Lordship, before that amendment could be carried out,
Once again.
unfortunately that applicant passed away. Now, Your Lordship, the petitioner in this application is the daughter of the executor who had originally
You
filed
only
this.
want to change the name.
So all I'm praying, Your Lordship, if Your Lordship comes to page 93, the applicant is changing, Your Lordship. Next is, if Your Lordship
What is
comes to
107?
107, Lordship.
Same greening.
Your Lordship, because along with the probate application, which is being converted to letter of administration, all the affidavit of assets and everything has to be re-verified, Your Lordship.
So contained in page 93. That amendments you are seeking for.
Yes, Your Lordship. 93 onwards. And if Your Lordship kindly comes to
In view of subsequent death, an amendment of the probate application became necessary, for which GA 5 of 25 has been filed. Proposed amendments, a plain copy of plain containing proposed amendments delineated with green ink is annexed herewith. Full stop. It is submitted that although previously amendments were allowed, those amendments were not given effect to. The department shall take into consideration this issue. GA 5 of 25 is formal in nature. Accordingly, prayer A to B of the master summon is allowed. GA 5 of 25 is disposed of. Department is directed to do the needful.
Your Lordship, only I want to bring Your Lordship's kind notice that the prayer B is not a consequential, but Your Lordship, since the applicant is coming in for the letter of administration, I am only seeking leave to file the affidavits of consent of all the legates.
That is given.
Yes. Great.
A to D.
Your lordship, perhaps your lordship had dictated plaint, maybe
Petition. Petition. Copy of petition.
11.
The matter will appear in the list on 29th April.
Great.
Item 11.
11, I appear for the plaintiff, my lord. Today, my application is on board, my lord, for reimbursement of expenses.
Lordship, I am the administrator appointed in this matter. I have already filed my reports in compliance of the orders passed by the Honorable Court, Lordship. Lordship has passed orders that which vouchers can be reimbursed. Upon verification of the vouchers, I have filed a report, Lordship, which were handed over to me, the vouchers, bunch of the vouchers.
Be paid.
Vouchers which according to me can be paid, Lordship. I have filed the report and handed over the copies to the parties.
Outstanding.
After verification with them, lord, claims that we are making.
Your remuneration 50,100 is outstanding.
Lordship, one of the parties, the defendants, are not paying regularly, Lordship.
The defendant.
Lord, on the
Your Honor,
No, first thing one by one. First thing is which documents can be allowed.
Yes, Lordship. That report I have been filed, Lordship.
Show me, tell me which part you are referred to.
Lordship, kindly see the report filed by me, Lordship, on...
There is a table.
Yes, Lordship.
Certain amounts preferred so and so are there.
Yes, Lordship.
Are you referring to it?
Yes, Lordship.
This amount can be paid.
Yes, Lordship. These can be reimbursed, Lordship.
Reimbursed to?
Reimbursed to the executor, Lordship.
to the plaintiff.
These are expenses for?
These are the expenses the executors has incurred, Lordship. The vouchers which had been handed over to me.
But these expenses shall be borne by you. You are the administrator.
No, I am the administrator independently appointed by the court, Lordship. The executor had incurred certain expenses previously.
Now they will not do.
No. Those vouchers has been handed over to me
for cross verification, Lord. These expenses
cross verification, and the amount can be reimbursed to the executor. So the court has directed me to verify the vouchers, which amounts can be reimbursed to the executor.
Mr. Medora, my lord, will apprise my lord better. He is
So
appearing.
I want to understand, you said an amount of 50,100 on account of remuneration of the administrator pending.
That is a separate report, Lordship.
Tell me, is pending. What about the report of payment? Is there any other report than this?
Yes, Lordship. There are 2 reports filed by me, Lordship.
So show me the other report.
Report dated 30th January 2025.
30th January regarding your remuneration, unpaid remuneration.
30th January 2025 is the report regarding the vouchers which can be reimbursed, Lordship.
No, not 30th January. It is 10th February 2025.
30th January 2025 is the report filed by me.
Just a minute. Yes, 30th January is respect to the vouchers.
Yes, Lordship.
What is the total amount?
35,142.
3,51,375 total can be reimbursed, Lordship, according to me.
Where have you stated this?
The total amount is the
acceptable amount. Where have you mentioned the acceptable amount?
Paragraph 11, the total amount.
Total amount. What is the total?
Total I have not written. The total is the.
Why? How can he pass order? Was it very difficult task for you? Was it very difficult? Tell me. A supplementary report shall be filed by the administrator pendently on or before the returnable date on payable on admissibility of claims raised through vouchers. The report shall be submitted on or before 1st April without fail.
Is returnable.
The matter will appear in the list on 1st April.
Extremely grateful.
This is a matter of common sense. Nothing more, nothing less.
Item 12. Item number 12.
My lord, this is my lord, my application, my lord, for grant of probate, my lord.
What is the
Says-
status?
My lord, the status, my lord, I believe on the last occasion, my lord had passed an order, my lord, calling for a report from the department, my lord.
আগের order থেকে? There is no caveat.
There are no caveats.
The report of the learned registrar in insolvency in charge dated 7/3/2025 be kept in record. According to this report, in spite of issues of citations and notices, no caveat has been filed. Full stop. The proceeding is still uncontentious. Full stop. Let the will be proved in solemn form. 6. Date bolo. 8th April for witness action.
Grateful.
Bring your witness, prove it will.
Very well. Grateful.
Item 13.
My lord, may I beg
They
to
are waiting till now.
My lord, I am seeking only adjournment of this proceeding up to 3rd April because of the fact, my lord, so far this probate application is concerned, I am seeking certain amendments. And the amendment application can too expected to appear day after tomorrow. So, lord, some time is required.
On prayer of the learned counsel, Mr. Chakraborty, the matter is adjourned to
3rd April, my lord.
3rd April.
Grateful, my lord, extremely grateful.
14.
Your Lordship, may it please this court, I appear for the respondent in this matter.
What is J7?
It is a joint petition, Your Lordship, for withdrawal of this testamentary suit. The parties have reached an amicable settlement. We have annexed the
Look, our
memorandum.
testamentary court has only one thing to do, either to allow probate or to refuse it. So we are not concerned with, this court is not concerned with settlement. You just withdraw it, I will pass that order.
Yes,
No
Your Lordship,
settlement
just-
can be recorded because it is not a civil suit. Dismissed as withdrawn.
Your Lordship, there has
Case 7 of 25 is filed by the parties, here, both parties.
both parties.
Both the parties praying for withdrawal of the suit. Instant suit. Full stop. Accordingly, that the suit be disposed of as withdrawn. GS7 of 25 stands disposed of.
Your Lordship, there were certain orders which were passed in connection to the suit. We have made a specific prayer for vacating those orders as well. So if that could be on record, Your Lordship. Both parties have agreed to that.
Where is the master summon? That is not in your prayer.
Yes,
All
sir.
interim order stands vacated. Because all interim order stands vacated.
Much obliged, Your Lordship. Much obliged.